Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate at Samfiru Tumarkin. Thanks for joining us for today's employment law question and answer period. I'll be taking your questions for the next half hour, so feel free to put your questions in the chat. We're going to try and get to as many of them as possible. We have also a lot more information on our website. If you don't get an answer to what you're looking for here today, visit us at employmentlawyer.ca, where you'll find a trove of information on your employment rights, your severance rights, and all of that. So feel free to visit our site. But first, I'm here today for the next half hour, so feel free to put in your question. I'm going to get to them as soon as they come in. I wanted to talk to everyone today a little bit about a weird kind of wrinkle in employment law that some people might not be familiar with. That's the concept of inducement. So what that means, essentially, as many of you may know, your length of service is a factor in determining how much severance you're entitled to. And of course, shorter term employees are usually entitled to less severance than someone who's been there a long time. What happens is some situations where an employee is recruited or induced away from their employer to go work for a new company. And at that new company, they only stay a short while. So oftentimes it's possible to have some of the time that you were at the old company count towards your severance. So say you're a 6 months employee, but you were induced to go work for this new company and you had a 20 years of service at the other company. You won't be treated as just a 6-month employee. In fact, some of the time that you spent at that other company will count towards your severance entitlements. All right. So instead of receiving, maybe 2 or 3 months of severance, you might be entitled to up to 12 months of severance or even more. So definitely something to look out for. If you've just been recently terminated, but someone recruited you, they told you, come work with us. We see a great future for us together. You weren't looking to leave. You didn't apply. They reached out to you. That's a situation where inducement might be an issue that you need to look at when you're discussing your severance pay entitlements with your employer or when you're having us do that for you. Now, we already have our first question coming in from MP. It asks, can we extend written contracts to long tenure employees that have never had a written contract, but just a verbal agreement? No change of terms, but just to formalize it on paper. So those of you who come to the show often will tell you, I'm not a huge fan of written contracts personally, all right? I know a lot of people want to have something in writing, and you're free to do that. But in my experience, when you're presented with a contract after you've been working somewhere for a long time without a written contract, it's not just to formalize what the arrangement is, all right? It's not just to say, well, your hours are 9 to 5, here are your duties, here's how much vacation pay you get, or anything like that. It's to limit your rights. That's why people enter into employment contracts. That's why employers draft them, to limit your rights that you would otherwise have in the absence of an employment contract. So what's important to know is when there is no contract, well, then you look at the law to see what your entitlements are, all right? There's laws that govern work, like the employment standards legislation. There's judge-made law that deals with, what your severance entitlements might be, what your non-competition clause obligations are, things like that. Those exist whether or not you have an employment contract, and those apply to you when you don't have an employment contract. So the point of the employment contract is to restrict that, to reduce that, to take away your rights so that you have less rights during your employment. So if you were to tell me, listen, I just want to give my employer a sort of one-pager that explains what the terms of my arrangement is with them, that's okay, I guess. I won't say that that's bad, but it's a bit superfluous if you guys know what the terms are, and the big one is, what's your rate of pay? That's on your pay stub. You don't need a contract to say that. And how much vacation do you get? And that's based on past practice. If you got 4 weeks last year, why wouldn't it be 4 weeks this year, right? Something needs to have happened for them to say, well, it's no longer 4 weeks, it's now 2 weeks, right? So long as, everyone understands what the employment conditions are, going into contracts and stuff like that, I don't think it's necessarily in the employee's best interest. First, what tends to happen is it's the employer and their lawyer who are drafting the contract, okay? And unless you're willing to commit to spending some money on a lawyer yourself to have it reviewed, and you're going in there with an imbalance of information, right? And you're thinking, well, the employer is doing this out of my best interest to have everything formalized and all of that. I don't think that's generally the reason why you're presented with an employment contract. As I said before, you're generally presented with an employment contract to benefit the person who drafted the contract, which is the employer. So keep that in mind when you're asking someone to draft a contract for you. So my advice is, better to, if you're on one of those employees who doesn't have an employment contract, better to keep it that way, in my view. We have another question coming in from Frank Pisano. Frank asks, I'm the top exec in Canada for my company with 15 plus years. No resignation terms in my contract. My direct boss is in the States. How can I resign without retaliation from a hostile employer? So you shouldn't expect retaliation for resigning, all right? I don't know exactly what you have in mind in terms of retaliation. When you're a top executive, as you are, Frank, you have to think that you might need to give a bit more notice than just 2 weeks, okay? Basically, what I advise, more senior management, I tell them, listen, you got to think about long and hard, how much time is it going to take this company to find your replacement, right? You have a role that's quite central and critical to the company. You might have to give more than 2 weeks. I would say propose to them, something like a month and see what they say. They might need more time. They might want you out of there, yesterday, right? So keep that in mind, but don't just simply say, well, this is my last day. You won't see me tomorrow. That could cause some problems for you. The higher up you are, the more problems it can cause you. I've seen people get sued because they didn't provide enough notice of resignation. So keep that in mind, all right? So what you want to, in terms of retaliation, you do want to leave on good terms, if it's only to get a good reference letter. But other than that, you're allowed to resign. I just want to remind people of that. You're allowed to resign. It's not required that you stay with a company that isn't working out for you anymore. So, just there's a way of doing it. It's a professional decision. It's a business decision. It's not a personal decision necessarily. And treat it as a business decision. Say, well, listen, I have another opportunity that I want to explore, and that's what I'm going to go do. I don't want to leave you in the lurch. Here's my 1 month notice. Let me know if that's enough. If you need more time, let me know that too. If you need less time, let me know that too. I'm happy to work with you. I don't want to cause more problems than I already am, but I am leaving, right? That's basically what the message needs to be. We have another question coming in from KN2 on YouTube. I'm being forced to move into a cybersecurity position and not being paid for the training. I do not want this position. What can I do? Well, that's interesting. So you didn't tell me what your previous position was, KN2. Yeah, I don't know that. So that might change my answer. If you want to put that in the chat, please go ahead. Essentially, you shouldn't be paid. You shouldn't go unpaid for doing work. All right. So I don't understand what their expectation is of when you're supposed to do this training, but you should be paid for that. Furthermore, generally a job change, a major change in job duties can be a constructive dismissal, which means, KN2, that you may be entitled to quit. And even though you're quitting, go after your severance, telling the employer, well, listen, you forced me to quit. You're giving me a job I don't want. I never asked for this job. I had another job. Why can't I keep that job? And if you don't want to let me keep that job, then just do the right thing, terminate me on a without cause basis and pay me my severance. That's like I was just telling the previous chatter. Basically, this is a business decision. If the business doesn't have a role for you, then they have to do the right thing and terminate you with severance. All right. So they can't force you to resign. They can't ask you to work in a new role you don't want. So definitely just tell them this doesn't work for me. What are my options? Because I either want the older role that I had, certainly don't want to do no unpaid training, and I don't want to do this cybersecurity role either. So either it's my old job or terminate me with my severance. Those are your options, because these other options that you're presenting to me just don't work for me, and I don't want to accept this role. We have a question from Carlito on YouTube. What determines getting a minimum versus full severance pay in Ontario? That's a great question, Carlito. So essentially, I'll just set that up a little bit for you. So there are basically two ways of calculating severance. All right. I was speaking earlier in the show about employment standards legislation and then judge-made law. So employment standard legislation in Ontario, the Employment Standards Act, sets out a minimum amount of severance that you're entitled to when you're terminated. So in Ontario, it's especially complicated because there are two kind of pots of severance that you can get. You can get one that's called severance pay, and then you can get another one that's called termination pay. All right. So to get severance pay, you need to work for a relatively large employer, whereas everyone, no matter where they work, are entitled to termination pay when they're terminated. And it's only based on your years of service, and it's only a week per year of service up to a maximum of 8 weeks. All right. Now, the thing to know about that is that's an absolute minimum. And as I told you before, you can have a judge you can go ask a judge how much severance you're entitled to. And a judge is generally not going to give you the minimum. All right. The judge is going to give you what they think is a reasonable amount of severance for you to find a new comparable job. All right. And a judge is going to look at four main factors, which are your age, your length of service, the type of job that you had, how senior a job it was, and the availability of similar work. And then the judge is going to give you something that's in the range of, I would say, 4 weeks per year, if not more, right? So we're well over the 1 week per year to a maximum of 8 weeks that you have in the minimum employment standards legislation. So what situation where you only get the minimum? Really, there's only one situation that comes to mind, is if you've signed a contract. To come back to our earlier discussion about contracts, if you've signed a contract where you've agreed that that's all you'll get when you're terminated. And those are called termination clauses. If you watch the show regularly, you'll hear us talk about termination clauses a lot. So termination clause allows the employer to say, well, I'm going to pay you something if I terminate you on a without cause basis. But what I'm going to pay you is the absolute minimum that I have to pay you, which is, what's set out in the Employment Standards Act, and nothing more. So you're going to give up your right to have a judge determine how much severance you're entitled to. You're going to give up your right to be able to claim that you're owed 4 months per year. And there you have it. And then you go ahead and say, well, you're giving me this contract because it's in our best interest, so I'm going to sign. Big mistake. That's why I tell people, listen, if you want to sign a contract, commit to having it reviewed by a lawyer. That's my opinion. Otherwise, don't be asking for contracts you don't understand. All right. You're just, creating problems for yourself. Other than that, Carlito, I would say that if you haven't signed a contract that has an enforceable termination clause, then you shouldn't be only getting the minimums in most cases. All right. So definitely, if that's all your employer is offering you, reach out to us. We'll be happy to review your severance offer and let you know what we think you're entitled to. And in fact, we've made it so simple for you to figure out what your entitlements might be. We have a really nifty tool. I talk about it every show, but it's really because I like it a lot. It's our severance pay calculator. So you can go to our website called Severance Pay Calculator and answer 4 easy questions, and we'll give you an estimate of what we think your entitlements might be if you get terminated. All right. So you can visit pocketemploymentlawyer.ca and find our severance pay calculator there. And we'll be able to give you an estimate of what you're owed, compare that to what you're being offered by your employer, and see if it's worth not giving us a call. I think that oftentimes people realize, I think I need to contact a lawyer at Samfiru Tumarkin. So feel free to reach out. We're always happy to chat. Now, following up on our next question here, we have a question from JX2. Do you find that severance pay for union positions are lower? I find that in non-union agreements, the severance tends to be high, but wages and other benefits may be lower. So that's a great question, JX2. So basically, what you're asking me, if I understand it, is, if you're unionized, will you get less severance if you're terminated? So there's nothing in the law that says that. But what ends up happening is that severance entitlements are usually negotiated along with everything else in a collective agreement. All right. So everything kind of gets hashed out. And they might say, well, listen, severance entitlements are 2 weeks per year of service, right? Which in many cases would be less than what you would get if you were non-unionized and going to court or having a lawyer review your severance, all right? So yes, that can be the case. So the union might say, well, we'll take only 2 weeks per year, but we're going to get other benefits. We might get, a couple extra dollars an hour, an extra week of vacation, whatever it is. That's the thing about collective agreements, is you kind of negotiate all components all at once, right? So that's been my experience as well. JX2, I gotta say, I don't do a lot of, or any really, unionized law. So that's kind of, I have people that come to me and say, well, listen, here's a collective agreement that I've seen a few, and oftentimes I see that, they're not for 4 weeks a year, right? They're for often half that. And then, the negotiation might happen when the layoffs happen, and basically, I don't know why, but the union is still saying, yeah, we'll have our members take 2 weeks. I don't personally think that's what their entitlements are. I think their entitlements are more, but that's between them and them and the employer, the union and the employer. All right, we have another question from Garrett G. Garrett is asking, if an employer fails to provide accommodations, terminates, rehires after HR appeal, after, I guess what you're saying, HR appeal is human rights appeal, then threaten my career upon rehiring with disability, then submit a resignation, then threats, is this termed retaliation? I'm sorry, Garrett. You're using the term DT here that I don't really understand what you're referring to. So basically, yes. If I understand your question correctly, Garrett, if you make a human rights accommodation request, if you have a request, for instance. You can't lift more than 50 pounds because of a back problem, for instance, and you ask for an accommodation, and then the employer refuses to accommodate you, and then, as you say, you went to human resources, and then basically were told you'd be accommodated, but then they create a poisoned work environment. That could be viewed as retaliation, which is also called reprisal. All right. If then you are forced to quit out of just how bad work has gotten, then you have a claim under human rights legislation for human rights compensation, which can be substantial. All right. The thing to keep in mind is you got to connect all those dots. Okay. So I used if a lot there. So you got to show that the reason that they created a poisoned work environment was because you asked for an accommodation, and the reason you resigned was because that was the reasonable thing to do given the poisoned work environment. All right. So it's, basically, generally when I have these kinds of fact patterns come in, I do a full case analysis with my clients. I'm like, exactly, tell me steps by step what happened. Tell me exactly why you think this was a poisoned work environment. What was poisoned about it? So people will often tell me, well, my employer was hostile or my employer was rude, right? That's not enough, all right? Basically, when you're preparing to speak to a lawyer about a poisoned work environment, you need to tell me exactly what the words were that were said, exactly how the person was being hostile, exactly how they retaliated against you, and how that's connected to your disability, all right? So I have a lot of situations where people feel a certain way about how they're being treated, and you can imagine the other side feels that the way they're treating you is completely appropriate. What I tell people is that ultimately it will be up to a judge down the line to decide whether that was a toxic work environment. All right. And so, what evidence do you have, right, that it was a toxic work environment? Do you have emails, or is it just, you say, well, they spoke to me in a loud tone? They're going to say, well, I used a normal tone. And you're in court, you don't have a recording of this, you don't have an email thread or anything like that. It becomes difficult to show that it was a poisoned work environment. So really what I tell people at the very least is start journaling these things. So honestly, like if you get a nasty performance review or whatever it is, go home and write down all the details, the W5 of it, the 5 Ws, who, where, when, what, and why. Write all of that down and keep that, because if in a year or two you're in a court case situation, you might not remember every single detail. But if you've prepared notes for yourself, that might jog your memory. And it also shows that you didn't kind of just at the 11th hour decide to claim that you were in a hostile work environment. So definitely think about that. But just to get to your answer to your question, Garrett, if you're starting to be treated differently and negatively because you asked for an accommodation, that can very well amount to retaliation. Absolutely. And if the poison work environment is what forced you to resign, then you may have entitlements under human rights legislation as well. So all of this is very factual, is the point I'm trying to make here. And so I need to know a little bit more about your facts to let you know whether you have a case or not. Feel free to reach out to us. We'll be happy to have a chat with you. We're at employmentlawyer.ca. Visit our website, employmentlawyer.ca. There's our number there. And you can even just leave us a line and we'll reach out to you so that you can get some advice from us on how to move forward here. So I was talking to you a little bit earlier about today about that LinkedIn post that I did where we were talking about inducement and how that might increase your severance. The LinkedIn post got actually a lot of interest from people because there is a kind of gotcha situation there. So if you are being recruited to go work somewhere else and you're giving up a long-term job that you had secure employment for, you go to this new job and they say, okay, now let's formalize things. Let's just sign an employment contract before you start. Okay. And you go ahead and you see in there in the employment contract, there's a probationary period of 3 months. Well, you lose that inducement argument once you sign that contract with that probationary period. Okay. The logic is if you were switching over to a new job with the prospect of working at the new job for a long time, then why would you sign a clause that allows them to terminate you with no severance within 3 months, right? So what I'm saying is if they're, bringing you over from somewhere else, promising you a raise or long-term employment or a promotion or anything like that, watch out for the probation clause. If you see it, tell them, listen, I'm not coming here, leaving my secure job if you can terminate me within 3 months. So you got to take that up, all right? I am not going to be subject to a probationary period, right? And you have some leverage here because you haven't left your old job yet, right? But if you sign that without even realizing, people think probation periods are standard. Everyone has that. That's not true. Not everyone has a probation period. All right. So you're allowed to say, I'm not signing that if you keep that probation period in there, because I don't want to lose the good job that I have and this job, in the space of 3 months, right? I'm doing this because I want my career to advance, not to take a step back. All right. So think about that. We have a question from Adrian on YouTube. My employer forced me to work on my day off at a newly opened location. I said no several times, but I was put on the schedule and forced to work anyways. After I've tried refusing to work again, I was fired and not paid the overtime I was owed. So what can I do? So a few options are available to you, Adrian. So I'm not sure which province you're in. So we service people in Alberta, Ontario, and British Columbia. We're in Canada. And so what I say applies to these 3 provinces, but each province has a Ministry of Labor where you can go and make a complaint against your employer for a few things. Firstly, for not paying you your overtime pay. The Ministry of Labor can force the employer to pay you your overtime pay. Probably for not paying you severance or termination pay, because, refusing to work on a day you're not scheduled to work is not a good reason to terminate you without severance. So you can see about that. And depending on how long you've been there, you may be entitled to more severance, in which case you should reach out to us and we can discuss with you what kind of severance entitlements you might be eligible for. Or, as I said before, Adrian, you can just, if you want to just find out right away, visit pocketemploymentlawyer.ca. Pocketemploymentlawyer.ca. It's got our severance pay calculator. You answer 4 easy questions, no obligations, where you don't have to create an account or anything like that, and it's completely anonymous. And you'll be able to find out what your severance pay, what your severance entitlements might be. So pocketemploymentlawyer.ca is right there on the screen. We got a question on Twitter from Mac. Mac is asking, please explain why unionized employees cannot sue their employer. Can this be challenged? So not really, Mac. It can't really be challenged. There's very, very limited situations where a unionized worker can sue an employer. So it kind of boils down to this. Basically, there's a bit of history involved, but essentially when unions became prevalent in the 40s and 50s, governments enacted legislation and enacted laws to kind of put a framework around unionized workplaces. I mean, you don't have to go that far back where unions were illegal, where there were, wildcat strikes, where there were riots, where there was deaths related to, strikes and unionized workplaces and all of that. So there was quite a bit of unrest. And so after a few years, basically governments in the US, Canada, then Europe and elsewhere decided, well, listen, let's allow unions and let's put a framework around it. All right. And one of that framework was unions and employers, if they have a dispute, they go to arbitration at the labor board or another arbitrator that's agreed to by the parties. All right. That means unions don't go to court. Employers don't go to court over their unionized workers. All of that is handled at the arbitration. And who's your representative? When you're non-unionized, you can hire me to be your lawyer, to be your representative in court. All right. When you're unionized and you want to bring an arbitration against your employer, your representative is going to be your union. Okay. And so basically, if you have a dispute with your employer, the first step is to go to your union rep. And because you have this arbitration framework, then you can't access the court. All right? It's basically the way it is. All right. So the first thing, if you sue your employer in court, the first thing your employer is going to do is bring a motion to quash your lawsuit, saying this should have been brought at arbitration. Judge, you have no jurisdiction to hear this. Throw this matter out of court and have Mr. Employee go through his union. And that's just the way it is. And it can't be challenged. It's part of our system. There's no really way to challenge it, unfortunately. So those were my comments for you today. I post a lot on LinkedIn. So if any of you are interested in following me on LinkedIn, just look me up. My name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I manage the Calgary office. That's my name, a little bit of a special spelling with the 2 L's, but look me up. I'm always happy to communicate and share tips with employees on LinkedIn or here as well. I talk about the show a lot, so I figure I'd talk about LinkedIn there as well. And we got a lot of content on LinkedIn as well, so feel free to follow Samfiru Tumarkin's page on LinkedIn as well. And tomorrow we're back again. Tomorrow's a disability law question and answer with Martin out of Vancouver. So feel free to reach out or to tune back in if you have questions about that. It's been a pleasure as always, and I hope to see you guys soon. Take care.